I can, Johnny.
Okay, you can hear me okay?
I can.
Okay, great.
If you want to start recording.
Let's give it another minute or so.
Okay.
We'll start it. Thank you.
Yep.
I think we already are recording.
Okay. All righty, we'll go ahead and get started. Good afternoon, everybody. My name is Johnnie Barton. I'm Chief Counsel to the Office of Open Government. I want to first of all thank you for attending this afternoon's webinar on the nuts and bolts of the Freedom of Information Act of 1976, what we refer to as DC FOIA. I believe all the staff of the Office of Open Government are on the training as well. Director Nikhil Allen, our legal team, which consists of Attorney Advisor Cherie DeBerry, a trial attorney Nicholas Weil, Attorney Advisor Anthony J. Serbo, and our paralegal assistant Kimberly Brown. And this is a introductory training on basically on the nuts and bolts of FOIA. We'll have a series of other training to follow, and we'll go ahead and get started. If you have any questions, you can go ahead and put them in the chat, or you can wait until the end and we'll do our due diligence to answer them. First, we're just going to go over a little bit about the statute itself. It's found in DC Official Code Section 2-531 exec. 2-531 is the public policy, and it's the public policy of the district that all persons are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and employees. To that end, the provisions of DC FOIA are to be construed with the view toward expansion of public access and the minimization of costs and time delays to persons requesting information. 2-532 are the right of access to public records, the allowable costs, and the time limits for responding to FOIA requests. 2-533 contains what needs to be in your letters of denial. 2-534, the exemptions from disclosure. 2-535 is a provision that requires any agency that has a public body with more than one member to make those final votes available to public inspection. 2-536, and we'll go into that a little later, is information which must be made available without the need of a FOIA request. 2-537, administrative appeals. 2-538, oversight of disclosure activities. Those are the requirements that pretty much capture FOIA responses and how we respond to them during the course of the fiscal year. 2-539 are the definitions utilized through DC FOIA, and it references the APA. And 2-54 is the short title, which is in fact the title, the real title of DC FOIA, which is the Freedom of Information Act of 1976. What I recommend is that, particularly if you're a new FOIA officer, that you make yourself familiar with these provisions, not very long, and also with the FOIA regulations as well. Here are some additional sources for interpreting DC FOIA and will be helpful in processing FOIA requests. And they're not in any order of particular supremacy. They're just, as I listed them, the DC FOIA regulations that are found at 1 DCMR section 400 exec. Some agencies that are independent and not subordinate to the mayor have their own FOIA regulations. Mayor's Office of Legal Counsel Advisory Opinions, or MALC, Freedom of Information Act appeals. case law, including federal case law, when the statutory provision in DC FOIA is also in federal FOIA. Although not binding, it is instructive, and there's a case that cites this. Department of Justice guidance. The Department of Justice puts out guidance on federal FOIA, and again, if those provisions in federal FOIA are similar or the same in DC FOIA, we can look to the Department of Justice guidance and their bulletins on these, interpreting these provisions. Office of Open Government Advisory Opinions. Agency program manuals. Some agencies, and this is a reference to the Department of Corrections agency manuals, have their own agency program manuals, which also deal with processing of FOIA requests. And finally, the Office of Government Information Systems, or OGIS, and that is the federal counterpart to the DC Office of Open Government. What are records under DC FOIA? As we know, any person has a right to inspect or to copy at their discretion any public record that agencies possess, but we need to understand and have a clear picture of what are records under DC FOIA. First, we want to deal with DC Official Code 2-536, which is FOIA's proactive disclosure provision. These are items that have to be made publicly available on the agency's website or on the internet, and a person does not have to submit a FOIA request for this information. It has to be already publicly available. Employee salary, title, and employment dates, contract expenditures, budget information, manuals, policies, rules, final opinions and orders, meeting minutes of open proceedings of public bodies. By definition in the DC Code, public records include all books, papers, maps, photographs, cards, tapes, recording, vote data, included ballot definition material, raw data, and ballot images, or other documentary materials, regardless of physical form or characteristics, prepared, owned, used, in the possession of, or retained by a public body. Public records include information stored in electronic format. See also DC Official Code Section 2, and there's a dash missing here, 2-539, 10, 2-50218, and 2-1701, 13, which we will get into a little bit later. I'll text you that information. Is the text a public record under DC FOIA? And what I'd like for you all to do is to basically, we're going to go through some responses to the hypotheticals for you to make a mental note, or if you like to write it down on a piece of paper, your response, and then we'll look at the proper response so that we're all on the same accord. Johnnie tells fellow employee, I'm looking for my government-issued cell phone, and will text those government statistics the office has compiled to your government cell phone. Are text messages public records? Here are our responses to choose from. No, text messages are not public records. No, if it's between government employees, it's private. C, it's up to each agency director to decide if they want agency text message to be records. Yes, they meet the definition of public record. So I'll give you a couple minutes to ponder upon those responses and to choose the best response to the questions. The question, are text message public records? All right. D is the correct answered. In a March 16th, 2022 advisory opinion, the Director of Open Government opined that a district government employee that conducts government business via a text or similar electronic method under the scope of employment creates a public record under DC FOIA. There's currently some legislation, emergency and pending temporary legislation that also bears on this definition of text message being a public record under DC FOIA. The Fidelity and Access to Government Communications Clarification Emergency Amendment Act of 2023. It expires on June 22nd. There's currently a temporary act, 25-0091, that's under congressional review with June 13th, 2023 as a projected law date. Both these measures amend the definition of public record in the District of Columbia Public Records Management Act of 1985 as electronic mail or other communications transmitted electronically, including any electronic messaging service or mobile messaging application, to mean it's a public record under District of Columbia law. So what if we store agency records on a personal server and email account at the agency director's home or off-site? So it's not in a government facility per se, but they're government records and they're stored on a personal server or an email account at the agency's director's home or off-site. The responses are, they are still agency records subject to DC FOIA. Since they are not maintained by the government, they are therefore not public records. They are not government records and lose their character once on the private server or stored off-site. So here are your responses to select from. They are still agency records subject to FOIA. They are not maintained by the government and therefore not public records. They're not government records and lose their character once on the private server or stored off-site. And this training will be made available to you all after the presentation is available. It'll be on our website and it'll be available to you via email. And I think we also will have it in our chat once we correct my errors. So there are your responses to select from. I'll give you a moment to ponder on those. A is the correct response. They are public records subject to FOIA. So simply because they are not in a government agency per se, if they're government records, they're on a private server, or if they're in someone's home, they're still public records subject to DC FOIA. When we go back to the definition of public record, the term public record applies where the content is merely prepared or used by a public body. The means of storage is immaterial. Government personnel cannot evade DC FOIA simply by preparing records on media they happen to own. And there is a case law, a federal case that has brought this out. Competitive Enterprises Institute versus the Office of Science and Technology Policy, holding that where an agency refused to provide requested records on the basis that the agency had maintained them on a private email account in his name at a site other than the government email site, which the government agency had searched, the request of FOIA compliance action was erroneously dismissed because an agency could not shield its records under FOIA by the expedient of storing them in a private email account controlled by the agency head. If the agency had controlled what would otherwise be an agency record, and is still an agency record and still must be searched or produced, it was not apparent that the domain where the email account was maintained controlled the emails therein to the exclusion of the user. The agency's claim was inconsistent with the purpose of FOIA, which was to serve the citizens' right to be informed about their government. So under DC FOIA, DC Official Code Section 2-532, subsection A, a person has a right to inspect and at his or her discretion to copy any public record of a public body except as expressly provided by FOIA's exemptions. And we'll get into the exemptions briefly, but we want to ask a question, a basic question. Who is any person that may submit a DC FOIA request? Who is any person that may submit a DC FOIA request? Does any person refer to a District of Columbia resident only? Any natural person, which means that's someone other than someone who's not other than a corporation, a live human being, or not a corporate entity? A person, natural or corporate, regardless of their residency or location. So who does any person under DC FOIA refer to? There are your responses to choose from. And we want you to choose the location, choose the response that is the most appropriate and best response to the question. The correct response is C. Now in Virginia, you must be a resident to submit a FOIA request for records in that jurisdiction. However, under DC FOIA, any person includes non-residents and corporate entities. See DC Official Code sections 2-5398 and 2-5029. Does any person include an anonymous requester? Does any person include an anonymous requester? Basically, does the person have to identify him or herself in order to submit a FOIA request under DC FOIA? Suppose you get this FOIA request, and it's an anonymous FOIA request. It's from no way to tell who I am, haha@hotmail.com, and it's to the FOIA officer. It has today's date, and in the subject line it says DC FOIA request. Dear FOIA officer, I am requesting copies of all records you have that mention Ray's Boom Boom Room nightclub. I'm willing to pay up to $100 for these records. The records may be sent to me or any correspondence regarding this request at my email address. No way to tell who I am, haha@hotmail.com. Thank you and have a wonderful day. So what are we going to do with this FOIA request? It's from an anonymous requester. Does have an email address. It's addressed to the FOIA officer. Has in the subject line, it's a FOIA request. They tell her how much they're willing to pay for it. And they give us an email address where we can reach them to send the records or to, if we have any further questions about the FOIA request. So what are you going to do with the request? A, email the requester and ask for their name, telephone number, and mailing address. B, delete it from your inbox as trash. C, send it to your subordinate to handle if you are a supervisor, or to your supervisor if you're subordinate and request they handle it. D, process the request with the email address you have. So there are your four responses to choose from to answer the question how to deal with this anonymous FOIA request that doesn't have a name, a telephone number, or a mailing address, but it does have an email address. I'll give you a couple seconds to make your selection. D is correct. An anonymous person may request records under DC FOIA. The regulations implementing DC FOIA, 1 DCMR Section 402.3 do not require that the requester identify him or herself. In relevant part, the provisions state a request should include a daytime telephone number, email address, or mailing address for the requester. Further, the Mayor's Office of Legal Counsel found in the FOIA appeal that an anonymous person is entitled to submit a FOIA request under DC law, and their identity is generally immaterial except for the determining fees and for course logging and appeal. We work with private contractors. Do any records include private contractor records? So many agencies have agreements, legal agreements, contracts with private contractors to do work on their behalf. The question is, do any records include private contractor records? Our responses are, DC FOIA doesn't reach these records. Yes, if the contractors are performing a government function. C, DC FOIA doesn't address this issue. D, yes, but only if the contractors don't mind sharing the records. So if it's a private contractor that's employed by a district agency and they have records, are those records, do any records include those contractors' records? And the proposed responses are, DC FOIA doesn't reach these records. Yes, if the contractors are performing a government function. DC FOIA doesn't address this issue. Yes, but only if the contractors don't mind sharing the records. So we give you a chance to ponder those proposed responses and choose or select the response that best answers the question. B is the correct response. A public body shall make available for public inspection and copying any record produced or controlled or collected pursuant to a contract with a private contractor to perform a public function. And the public body with programming responsibility for the contractor shall be responsible for making such records available to the same extent as if the records were maintained by the public body. DC Official Code, Section 2-532A-3. So if your agency has a contract with a private contractor and that private contractor is performing a public function, those records are subject to DC FOIA, and you as the public body with programming responsibility for the contractor is responsible for answering any FOIA requests or making those records available as if they were maintained by you. We want to move to the response time to a FOIA request. For records other than body-worn camera recordings, an agency must respond within 15 business days, and that excludes Saturdays, Sundays, and legal holidays. DC Official Code, Section 2-532C1. For body-worn camera recordings, an agency must respond within 25 business days, DC Official Code 2-532C2A. However, in unusual circumstances, the agency may invoke an additional 10-day extension by written notice to the requester setting forth the reason for the extension and the expected date for the determination. DC Official Code Section 2-532D1. DC Official Code 2-532E provides that the failure to timely respond to a FOIA request is deemed a constructive denial of the request, and the requester can go ahead and start to appeal. And in order to lawfully invoke that 10-day extension, it has to be done during that initial 15-day period. You can't wait till after the 15-day period has expired and then say, I'm going to invoke the additional 10-day extension. You need to let the requester know prior to the expiration of that 15-day period that you're going to invoke the extension. And again, the extension can only be invoked for unusual circumstances. So we need to determine under DC FOIA what are unusual circumstances. Our little scenario is as follows. FOIA officer believes the request for the review of 20 emails given other non-FOIA responsibilities and the FOIA assistant being on leave to be unusual circumstances and invokes the extension. So the FOIA officer believes that because they got 20 emails, some other responsibilities unrelated to FOIA, and the other FOIA assistant is on leave to be unusual circumstances, and they inform the requester that because of unusual circumstances, they're going to extend the 15-day period an additional 10-day period. Here are our proposed responses. Sounds right, sounds unusual, and I think that's all right. B, DC FOIA states what are unusual circumstances. C, DC FOIA does not provide guidance on the issue. This is decided by the agency guidelines. So what are unusual circumstances? According to our FOIA officer, they invoked them because of the little situation with 20 emails, some other non-FOIA responsibilities, and their help is on leave. Does that sound right and okay? Or does DC FOIA state what are unusual circumstances? Or does DC FOIA not provide guidance on the issue and the individual agency decides by its guidelines what are unusual circumstances? B is correct. DC Official Code Section 2-532D2, unusual circumstances are defined as the need to search for, collect, and appropriately examine a voluminous amount of separate and distinct records that are demanded in a single request, or the need for consultation which shall be conducted with all practicable speed with another public body having a substantial interest in the determination of the request, or among two or more components of a public body having a substantial subject matter interest therein, or for body-worn camera recordings, the inability to procure a vendor that is able to perform the redactions within the 25-day period provided under FOIA law. I'll give you an example of our second scenario. I think the first one is pretty clear, the need to search for, collect, and appropriately examine a voluminous amount of separate and distinct records that are demanded in one request. The second one, let's take a 911 call that comes in to the Office of Unified Communication. Well, MPD, fire EMS, or some other law enforcement agency may also have an interest in that recording, or two or more components of the Office of Unified Communication. If that be the case, it is lawful to invoke the additional 10 business day extension because another public body, DC MPD or DC Fire and EMS, has a substantial interest in the determination of the request, or if two components of the Office of Unified Communications have a substantial subject matter interest in the request. I'm going to deviate from the standard presentation for a minute and talk about how communication can result in cooperation in processing a FOIA request. I took my car, and this is just a hypothetical, I took my car to the dealer to have some repairs done. They told me once I got there, after they took a look, they said, Mr. Barton, we've got to order some parts, and we'll have your car back to you probably by the close of business on Wednesday. Okay, so I took it in on Monday. They called me on Monday evening saying, Mr. Barton, your part came in a little earlier than we expected. We made the repair. Your car will be ready for pickup on Tuesday morning or anytime thereafter. Now, I'm elated at that point because they have communicated to me, pretty well, how long it was going to take. And I'm, surprised because they got me my car back earlier, and there were some open lines of communication. Scenario number two, I dropped my car off on Monday to the dealership. They said, we'll call you once we look it over and let you know what the issue is and when you can expect your car back. Well, I was pretty busy on Monday, so I didn't get a chance to call them, and they didn't call me. Tuesday, they didn't call me. Wednesday, they didn't call me. So on Thursday, I called them. They said, oh, we're going to call you today. We'll get back to you a little later on this evening. They don't call me back on Thursday. Well, it's Friday. I haven't heard anything. Excuse me. The lines of communications are not really clear. I'm a little upset at this point because they haven't communicated anything to me. On Friday, when they do call me, they say, well, your car is not going to be ready until sometime next week because we ordered a part on Monday because it wasn't in stock, and it's going to take until Wednesday to get here, and you might get your car back by Wednesday evening. Two different scenarios. The one I'm pleased with, the lines of communications were open. The second one I'm not so pleased with. I could have been pleased with the second scenario if the lines of communication were open and they notified me on Monday evening that they needed to get the part and that it was going to take a while for the car to be repaired. One of the chief complaints we received in the Office of Open Government regarding the process of FOIA requests is not that I didn't get the records, it's not that they withheld the records, and I think I should have got them. It's nobody's communicating with me. I sent this request in. I got initial acknowledgement. The time period is almost up, or the time period has elapsed. I've called. They say they're going to call me back. I haven't heard from anybody, and I'm a bit upset. It's important that we have found in the Office of Open Government to keep the lines of communication open because we found that effective and open communication can result in cooperation. If for some reason you don't meet the statutory period to respond to a FOIA request and you weren't able to invoke an extension, but the lines of communication were open, you sent that initial acknowledgement letter, you sent an email a day or so later saying, hey, requester, just want to let you know we're processing your requests. We don't have any questions about the request at this point. We hope to have it to you within the statutory period of time. And say if the requester shoots you an email a day or so later, you respond back, we're still working on it. that may be beneficial to you a little later on, because under FOIA and under the regulations, and we highly recommend, especially if you're a new FOIA officer, that you make yourself familiar with the regulations, that if the statutory period has expired to respond to a FOIA request, that you keep on processing it. You notify the requester, hey, we missed the deadline, before they notify you, and ask them to forego lodging an appeal, and tell them, hey, we may have it to you. We think we're going to have it to you by X date. Would you hold off on that appeal? We believe that if the lines of communication have been opened, that can result in some effective cooperation, and your requester may be willing to give you that little bit of extra time before they lodge an appeal. But if the lines of communication have been closed and there's been no back and forth, no response to an email the day after the request was due, or something when they just wanted to follow up with you, then that the lines of communication may not be so open, and that may result in you're not getting their cooperation and foregoing lodging an appeal at that time. There's a court case where a judge sort of weighed in on the need for cooperation and communication in the processing of FOIA requests. In a 2016 decision, the court stated, FOIA requester and the district entity receiving a request are not or should not be in an inherently adversarial relationship. I mean, so it's not a boxing match. It's not mixed martial arts cage battle. It's a relationship where there can be some cooperation and communication, even when there is going to be a total denial, we hope. There are some FOIA requesters who are just difficult, period. We know that. I think we've all run into those types. But in some instances, there may be an issue where effective communication can be helpful. So the court went on to say it's not an inherently adversarial relationship. Litigation is authorized as an enforcement mechanism, but it is not meant to be an inevitable path. Each case has presented its own discrete issues, but the constant is an apparent inability or unwillingness, and the court says on both parties to communicate effectively to achieve the objectives emanating FOIA. Both parties seem to have forgotten what FOIA is all about. And that's the case below that provides the court's sort of admonishment and advice, and hope that public bodies and individuals can cooperate. I need it yesterday. A request to expedite processing a DC FOIA request. You receive a DC FOIA request seeking expedited processing. The request states and demonstrated a compelling need as 5 USC, which is federal FOIA, Section 552A6E1 L2 1 and 2, federal FOIA's expedited review revision suggests. So you get that FOIA request saying you want it and you need it in a hurry. It cites federal FOIA, and you have demonstrated under federal FOIA a compelling need to get the record. What may you do? May you ignore the request completely, process the request under normal FOIA timeframes, and explain there is no expedited review under district law, or expedite the request and respond to the requester prior to the 15 calendar day period in any lawful extension. So you get that request asking for expedited review, citing federal FOIA as the basis for you to comply with the request. Should you ignore it, process the request under normal FOIA timeframes after explaining that there is no expedited review under district law, or expedite the request and respond to the requester prior to the 15 calendar day period in any unlawful exemption. Okay, something's out of order here. There is something else out of order here. Okay, we seem to be missing a slide. So we'll go back. The correct response is B. To process the request under normal FOIA timeframes and explain, and I will explain to the requester prior to responding, there is no expedited review under district law. District law does not contain the same or similar provision for expedited review as federal FOIA law does, and we will provide the record at the end of the 15-day period unless we have unless we find the need to invoke the additional extension. And there seems to be a problem. Somehow we wound up with an earlier presentation and not the later one. So the presentation you'll have is going to have the correct responses in it. This is an earlier presentation that I recognize now doesn't have all our, doesn't have the update and the changes that we made. I apologize for that, but we'll make do with it.
Johnny, would you like me to swap with you and share slides and you can present from those?
Do you have the updated one, Anthony?
I believe I do.
Okay, if you do, yeah.
Okay, give me 1 second.
Communication and cooperation gets the job done. Thank you so much, Anthony.
No problem.
Thank you all for bearing with us. Okay, Anthony, can I get you to go ahead and advance to the next? B is the correct response. Process the request under normal FOIA timeframes and explain there is no expedited review under district law. Well, while there is a provision to expedite federal FOIA requests, no similar provision is in DC FOIA. Anthony, can you go ahead and just proceed to the next slide? Thank you. Agency website reads, please use the FOIA portal for submitting all FOIA requests. It's the quickest method to get a FOIA response. The FOIA portal may be the simplest and best means to submit and process FOIA requests, but may an agency require the public to submit through the FOIA portal? So can you limit the way that the public submits a FOIA request? The choices are A, yes, because FOIA's public policy is to minimize costs and time delays to persons requesting information, and that is a correct recitation of the law at DC Official Code 2-531. Yes, because of the ease of use of the portal, and the portal is easy to use. No, an agency may not restrict the method a requester uses to submit a FOIA request. So those are your proposed responses. We'll ask you to select one. C is the correct response. No, an agency may not restrict the method a requester uses to submit a FOIA request. Under the regs, 1-DC MR section 4-201, 402.1, a request for a record of an agency may be made orally. Request may be mailed, faxed, or emailed. Now, if a request is made orally under the regulations, and we recommend that you do this, you request that the requester commit it to writing so that there's no confusion and you have some clarity as to what the requester wants. If the request is sent by email, fax, and regular mail, the request must state FOIA request on the subject line or envelope. And that's because once the FOIA request is received as a FOIA request, the clock starts to count. If we're unaware it's a FOIA request, then there's an issue as to when the agency received it, and there's some problems with the processing time. So, Anthony, if you can go to the next slide, please. We're going to go through the category of exemptions. We're just going to state basically what the 19 exemptions are. In particular, at a later training, and I believe Anthony Serbo is going to go through the most heavily relied upon exemptions under DC FOIA. But we'll go ahead and go through them and list them right now and make a few comments to some. Trade secrets and commercial or financial information. And the number that you see listed is the number that we usually associate with the FOIA exemption. So this would be exemption 1. Trade secrets and commercial or financial information, obtained from outside the government to the extent that disclosure would result in substantial harm to the competitive position of the person for whom the information was obtained. So it's trade secrets and commercial or financial information. One that is heavily relied upon, and Mr. Serbo will get into that, I'm sure, when he conducts his training later on, is the personal privacy exemption, exemption 2, information of a personal nature where the public disclosure thereof would constitute a clearly unwarranted invasion of personal privacy. My personal phone number, my social security number, my date of birth, my home address, my personal email versus my government email. All that information is information of a personal nature where public disclosure thereof would constitute a clearly unwarranted invasion of personal privacy. So that's the personal privacy exemption, which is exemption number 2. For exemption 2A, any body-worn camera recordings recorded by the Metropolitan Police Department inside a personal residence or related to an incident involving domestic violence, stalking, or sexual assault as defined by the DC Code. Investigatory records compiled for law enforcement purposes, including records of the counsel investigations and investigations conducted by the Office of Police Complaints, but only to the extent that the production of such records would interfere with enforcement proceedings, counsel investigations, or Office of Police Complaints ongoing investigations, deprive persons of a right to a fair trial or impartial adjudication, constitute an unwarranted invasion of personal privacy, and some refer to this as the other privacy exemption, but the two differ. This is an unwarranted invasion of personal privacy, where exemption 2 is a clearly a invasion of personal privacy. Excuse me. disclosure of the identity of a confidential source, and in the case of a record compiled by a law enforcement authority in the course of a criminal investigation or by an agency conducting a lawful national security intelligence investigation, confidential information furnished only by the confidential source, or it discloses investigative techniques and procedures not generally known outside the government or that endanger the life or physical safety of law enforcement personnel. Exemption 4 comprises what we call the common law discovery privileges. Attorney work product. And this applies to documents prepared by or for an attorney in anticipation of litigation, no matter the status or stage of the litigation. Attorney-client privilege protects confidential communications between the agency and the attorney. The deliberative process, we call the deliberative process privilege, the method through which an agency creates policies, opinions, rules, and regulations. To qualify for this exemption, the record must be both pre-decisional and deliberative. Pre-decisional documents are those generated before the adoption of an agency policy. A document is deliberative if it is part of the agency give and take process for which the decision is made. So I'm going to explain it a little bit like this. Regarding the deliberative process privilege, if there was a draft from myself to Director Allen, it's not final. Director Allen tells me, would you please look at this issue? Would you please address this concern? Would you please strike this provision? She sends it back to me. And if you get a FOIA request for any documents related to that particular subject, that draft is not going to be, not going to be releasable because we can rely on the deliberative process privilege. It's not final, it's a draft. And the public is entitled to the final result, but not the draft, because that may impact our ability to have frank and free discussions about matters. So the public under the deliberative process privilege is going to be entitled to the final and not drafts going back and forth from the supervisor to me as the subordinate. Exemption 5, future examination test questions. Of course, you may be able to get questions and responses from a previous test, but not future test exam questions for obvious reasons. Other statutes. There are several statutes in DC law that state that they are specifically, that the records are specifically exempt under DC FOIA. And the statute can also be a federal statute. But here's what it cannot be. It cannot be a regulation, which means that your agency cannot promulgate regulations exempting certain records from FOIA that are not going to be exempt from FOIA. It has to be a statute. The other statute has to be a statute, whether federal or district, that provides that the information, is exempt under DC FOIA. National security matters, for obvious reasons, antitrust investigations, arson investigations, Exemption 11, emergency response plans, Social Security and federal employee ID numbers under DC Official Code Section 47-2851.06. And this is information that the Business License Center would have. That information would also probably more likely than not be exempt under Exemption 2 as under the personal privacy exemption. Exemption 12, whistleblowers, unless the name of the employee is already publicly known. Homeland Security records, sealed criminal records, critical infrastructure. And if we have someone here from the Public Service Commission, I believe I see Angela Parsons from the PSC. This is your exemption. It applies only to entities regulated by the Public Service Commission. Teacher evaluations, certain information of private vehicles for hire, Uber, Lyft, and the like. Information and records of the Clemency Board. And finally, records in the custody of the unclaimed property administrator. If you've ever submitted a claim for records under the with the records administrator, you'll see why. Because they ask for your social security number. You have to give your name, your address, contact information, information of a very private and personal nature. All right. Next slide says, I am sincerely clueless as to this request. So you get a request and it is confusing, it's unclear. The FOIA requester seems to want this, or maybe they want that. It's not clear to you. So I should contact the requester and seek clarity, put the request on hold until the requester inquires about the request, put the request on hold, immediately contact the requester and seek clarity and inform the requester of the status. Document your attempts to reach the requester if you have someone who is not responsive. So you get one of these requests that is really not unclear, it's really unclear what the requester is asking for. What are your options? Okay, maybe out of order. Let's see. Okay, well, we'll go ahead and respond to that without the request. Under DC FOIA, a request should reasonably describe the desired records. Where possible, specific information regarding names, places, events, subjects, dates, files, title designations, or other information shall be supplied. When the information supplied by the requester is not sufficient to permit the identification and location of the request of the record by the agency without an unreasonable amount of effort, the requester shall be contacted and asked to supplement the request with the necessary information. Every reasonable effort should be made by the agency to assist in identifying the location of the requested information. So the quick response was to contact the requester, put the request on hold, notify them, response number C, notify them that you need some clarity, and until you get the clarity, the request is going to be on hold. Again, if you don't are unable to reach the requester, please document whether it was a phone call. We recommend if you have the contact information like an email address, or if the only contact information you have is mail, then you document it in your records and with a copy of it, so that you can prove when you responded. If the requested record cannot be located from the information supplied, the request shall be notified. When the Freedom of Information Officer pursuant to Section 402.5 of the regs contacts the requesters for additional information, then the request is deemed to be received when the Freedom of Information Officer receives the additional information. So in essence, you're not being penalized by not having a clear request. It's on hold, it's not designated as received until you get that information from the requester that clarifies it. Very interesting, very interesting. In addition to information, responsive records to a FOIA request contains a client's name, home address, telephone number. FOIA officer denies the request and withholds the entire record. Is this the correct decision? Yes, to protect the citizens' public privacy. No, it became public once turned over to the district. C, redact the personal information, then release. D, redact the name and release. So you get a FOIA request, and part of the responsive record has some personal information, including a private citizen's name, home address, and telephone number. How do you deal with that request? A says, protect the citizen's information and withhold the whole record. B says, hey, it became public information. Once it turned over to the district, and go ahead and release it. C, redact the personal information and release. D says, redact the name and then release. So C is the correct answer. Under the redaction rule, DC Official Code Section 2-534B, it allows for the release of records by concealing the portions, the exempt portions from public view. The justification for the deletion must be explained fully in writing, and to the extent of the deletion, to the extent possible, the deletion must be indicated on the portion of the record which is made available or published, unless including that indication would harm interests protected by an exemption under which the deletion is made. Again, if technically feasible, the extent of deletion and the specific exemption should be indicated at the place in the record where the deletion was made. Requester says, I want the information in an Excel spreadsheet. So you get a FOIA request requesting the responsive information be provided to them in an Excel spreadsheet. Now, the agency does not keep the requested information in Excel spreadsheet form. So what do? Should the FOIA officer create a spreadsheet for the requester? Should the FOIA officer, or should you supply the records in the form that the agency maintains? Or should you send the records to a third-party vendor, excuse me, that can timely create the spreadsheet? So think for a minute, and as you ponder as to what to do, and we'll go ahead and make our selection. B is the correct response. FOIA does not require an agency to create documents, not only documents, but opinions that are not in existence in response to an individual's request for information or to obtain records from another agency. Nor does an agency have to respond to questions disguised as a FOIA request. If you get a list of questions, not a request for documents, but a list for questions. How many people work for the DC government? What wards do they live in? How many people live in Maryland who work for the District of Government? If you get a list of questions under DC FOIA, you do not have to answer questions, nor do you have to create records or put records in a form that you don't maintain them in. And there's case law on it. The case is cited there at the bottom. Gone up in smoke. On Thursday, a few records contained solely on the director's external hard drive were destroyed by a small office fire, causing the hard drive to explode. The very next day, Friday, you received a FOIA submission requesting copies of some of the destroyed documents. You should go to your director and ask your director if he or she is able to recreate the documents. B, wait until DC Fire and EMS completes their report regarding the cause of the fire. Fire and EMS says it will take 6 months to complete its report. C, immediately notify the requester that the documents were destroyed and no longer exist. So the records were in existence, but they were destroyed, and they were destroyed prior to the request for them. And you get this request, and you have to respond to it. Here are your 3 responses. Let's choose one. And I think we're a little bit out of, there you go. Thanks, Anthony. C is the correct response. Remember, there's no obligation under DC FOIA to create records that don't exist. And under the regulations, and here's a very quick way to resolve this FOIA request. If a requested record is known to have been destroyed, and it was known to have been destroyed or otherwise disposed of, the requester should be so notified. Quick way to resolve that request: notify the requester that the requested record is not in existence, it was destroyed, and that's pretty much your response to that. Okay, let's talk a little bit about FOIA fees. And again, at a later training, I believe it's going to be Attorney Cherie DeBerry. She's going to go into detail about FOIA fees and the like. But under DC FOIA, as well as federal FOIA, a public body may establish and collect fees not to exceed the actual cost of searching for, reviewing, redacting, and making copies of records. Documents may be furnished without charge or at a reduced charge where a public body determines that waiver or the reduction of fees is in the public interest because furnishing the information can be considered as primarily benefiting the general public. If the person is requesting a fee waiver or reduction in fees under the regulations and under DC FOIA, they have to spell out why it's in the best interest, why it's in the public interest, that they get the public interest waiver should spell out how it's going to be in the public interest and generally benefiting the public. They can't just state that; they have to spell it out. And again, the agency can make a determination as to whether or not it meets the requisite for a fee waiver. Requesters fall, and the fees for requests fall into the following categories. Commercial requester, you can charge for search, duplication, and review charges. In educational, non-commercial, or scientific research or media, you can charge only for duplication. If the person or requester is not in A or B, they can be charged search and duplication charges. So here is when you have to know a little bit about who your requester is. Sometimes it's going to be clear from the face of the request. Sometimes it's not. If they're again requesting a waiver, you can inquire a bit and make a determination as to which of these categories they fall in, so that you can know how to assess the charges and what charges may be assessed to the specific category of requester. A requester seeking a waiver or reduction of fees shall provide a statement in his or her request letter explaining how the requested records will be used to benefit the general public. Again, just a statement. These records will be used to benefit the general public is not general enough, unless your agency wants to say it's general enough, but they have to explain under the regulations how it's going to be used to benefit the general public. Advance payment of fees is allowed under 2 circumstances. when the request will exceed, and you know in advance it's going to exceed $250, or if the requester has previously failed to pay pay for a previous request. If someone has requested from your agency records and they hadn't paid for them, and they come to you and ask for records, request again, you can say, hey, look, in order to get these records, you're going to have to pay in advance, or if the request, the cost to process the request is going to exceed $250. Of course, the fees are not payable to your agency. The fees are payable to the general fund, and the requester should be notified of that as well. Appeals. A requester who receives a letter of denial or where an agency fails to supply the record within the statutory time frame may file an administrative appeal with the Mayor's Office of Legal Counsel, or they may institute a proceeding in the DC Superior Court. Now, in your public denial, your denial response, you have to state the specific reasons for the denial, including the citations to the specific exemptions under DC Official Code 2-534 that you relied upon as the authority for the denial, the name or names of the public officials or employees responsible for the decision to deny the request, and you have to notify the requester of any administrative or judicial right to appeal under DC Official Code 2-537. So in your denial letter, you have to make sure that it has all that information in it. And again, you have to notify the requester of their rights to appeal. Appeals. If you get a notification from the Mayor's Office of Legal Counsel that that a requester has appealed a decision to deny a records request, you have within 5 days, excluding Saturdays, Sundays, or legal holidays, a receipt of the appeal to file your response. Now, you can request additional time to file the response by filing a written or email request with a copy to the requester within the 5-day period to the MOC and to the requester. If you fail to respond to the administrative appeal or to ask for an extension that's granted, then you may have waived your rights, and the MOC can go ahead and proceed on the appeal with what they have before them. There's some annual reporting requirements. Each year on February 1, you'll receive have to submit to the Secretary's office a response that details your public record disclosure activities for the preceding fiscal year. It'll ask how many requests were approved in full, denied in part, what provisions of FOIA you relied upon for exemptions, and that information is put into a public report that's delivered to the council and made publicly available. The OAG, former Corporation Counsel, submits an annual report on February 1, on or before February 1 of each year, which includes for the prior fiscal year a listing of the number of cases arising under FOIA, the exemptions involved in each case, and the disposition of the case, and the costs assessed pursuant to DC Official Code 2-538C. Here is our contact information. for the Office of Open Government. The director is Nicole M. Allen. She's the director of Open Government. That is her contact information. I'm the chief counsel. My contact information, Cherie DeBerry is our attorney advisor. Nicholas Well is our trial attorney. Anthony J. Serbo is our attorney advisor. And Kimberly Brown is our paralegal. That is all of our contact information. Feel free to contact us with any questions you may have regarding the processing of DC FOIA requests. Next up, and this is the first in a series of FOIA trainings. Next up, our next at bat is Director of Open Government, Nicole M. Allen, Esquire. On June 20th, 2023, at 2 p.m., she will present Effectively Managing the FOIA Process. This webinar covers the life cycle of responding to a FOIA request from receipt to processing and responding to the request. This webinar will provide comprehensive instruction on how to perform your duties as a FOIA officer. That is the end of our presentation. We want to thank you all for attending. I noticed that there were some questions in the chat. I want to thank my colleagues for addressing them, and we want to see if there are any unresolved questions that still need to be responded to. And if there's anyone who has any additional responses, feel free to let us know.
Yes, sir. Hello. How are you?
I'm fine. How are you?
I'm doing very well. Thanks for asking. I think you did a great job, first of all.
Well, thank you.
Okay, so I have a question. It's in reference to submission of payment. I have a requester. You know how we can have that specific requester. They always asking for the exact same thing every month or every 3 months or something like that. So we automatically pretty much know how much it's going to cost. You see what I mean? Let's say if the set cost was $100. So I have a requester like that, and the requester came up with the option of sending a lump sum check for $1,200. So that way it will be $100 for every month. Is that permissible, do you believe? Based upon what you've discussed, I now think it's not permissible, but I wanted to ask you just in case.
That's an interesting question. I've not been asked that before. Personally, I would not send any government money in advance of what I was owed. But I mean, it's just me. But
Right.
I will tell you. Send me your if you can put your just
Email?
send me your email information, and I will give you a specific response. And if anyone else is interested in that response, just email me and we'll get that to you. But you know, I would follow what the regulations say. Let them know what it's going to be and for the response, and deal with it that way. You know, but again, I'll check the regs and get you a more definitive response if that's not sufficient. And thank you so much.
This is Director Allen. I just want to interject. In the government, you can't prepay for anything. You're going to have an anti-deficiency problem with that. So I would say that's probably a no, because the person hasn't received government services. So I would say that probably not. You probably cannot receive those funds because you haven't rendered the services. So you would probably have an Anti-Deficiency Act problem.
Thank you, Director Allen. And I think we have our answer.
Okay, I appreciate that. Let me ask you, Ms. Allen, also. So the term, the word receive, does receive mean I actually received the check in hand, or receive mean I've actually processed the check through finance? Because I'm just trying to get a clear understanding. Because let's say if I were to do a situation to where Let's say if it was permissible for the person to send me 12 separate checks for $100 and I just hold it. Could I do
Well,
that?
the issue is that it hasn't happened yet. So he hasn't made a request from the way that you described it. It's a prospective occurrence. So the person is thinking that they're going to keep doing this every month. So it's in advance. So we don't do things in advance in the government. It has to actually happen. So it's a prepayment. In regular private sector life, a prepayment is no problem. But in the government, it has to actually be a service that's been received for payment. I believe. I would check with your general counsel on that. If you are the general counsel, then I think you can make that call, but look at the Anti-Deficiency Act
Okay.
to verify that you're not running into a problem with the Anti-Deficiency Act,
And,
because
and, and
Thank
that's
you
also,
so
only
much.
indicated by receiving funds in advance
and,
um, of an appropriation. That's how it would be. It's under those rules. That's a set of rules I think would apply to a prepayment. And you may
Right.
want to talk to your AFO. Those are the folks in the CFO's office who would be handling the money, but it would be seen as a prepayment. So that's, I guess, the rubric that you would analyze that under.
Thank
and,
you
and
so
also,
much.
and also the statute does say that you cannot accept advance payment uh, under FOIA unless the cost is going to exceed 250, or unless the requester has failed to pay in advance. So I think based on what Director Allen says, based on what the statute and the regulation says, um,
I
I
should
would not
scratch that.
charge it.
Okay. Thank you so much.
You're welcome. Thank you, Director Allen.
Oh, you're welcome.
Okay, we see a question from Elizabeth. What happens if a search results in 100,000 plus of emails or documents that need to be reviewed and redacted, and it is not just possible to do it in 15 days plus the 10-day extension? Is the government obligated to hire doc review team? Is the requester required to narrow their request? Well, there's a long and there's a couple variables that come into play here. First of all, under district law, there's no void for volume issue. So we can't deny, and I'm not saying that you're suggesting that we can't turn down a request because it's too large. Um, um, you do invoke the 15-day extension. What we advise is that, if possible, you contact the requester and find out what the requester actually wants. Some requesters may not really specify what they want, so they just ask for, things in general, and they may want something more specific. I would contact the requester and see if I can help them to narrow down the scope of the request. Also, as you get the documents that meet the request, and they go through the process of redaction or being withheld if necessary, I would roll those records out as you get them. See if you can set up a sort of a plan for the requester. Let the requester know, look, you know what you asked for. We're going to give you the records as you request them, and keep the lines of communication open. And I think you're on good and stable footing with that. I don't think you're obligated to hire a document review team, but again, it's always good with any request, especially if you know as a FOIA officer that is pretty broad, to contact the requester and to talk with him or her and say, hey, listen, we got your request. Is this really what you want? Or, is this more like what you want? And sometimes you'll find out just by talking with them that they really don't want everything that they seem to have suggested, and you can narrow the request that away. You're welcome, Elizabeth. And I want to thank Director Allen and the legal team, Anthony, Nick, and Kim, and Cherie for responding to the questions, and Anthony for, as always, I have to chuckle. I always have a problem with the technology, so today was no different. But thank you, Anthony, for having the ability to correct the presentation. So if there are no further questions right now, we're going to end the training. Again, thank you everyone for coming. We look forward to seeing you on June 20th at 2 p.m. And Director Allen will be leading the next presentation. We hope you have a great day, and feel free to contact us at any time with any questions that you have about DC FOIA, and we'll give you a response. Thanks so much and have a great afternoon.